Hey, what's up, everybody? So it's late than a motherfucker, and I'm on here doing things that I know damn well I shouldn't be doing at 1:54 a.m. in the morning. So I just got off a video call with Diva Divine Light, and we were talking about or debating, right? We were having a friendly debate about this Rkelly case. And one of the things came up in that debate was the double jeopardy situation with Rkelly's case in Illinois. Now, a quick recap is that in 2008, in the state, he was charged with certain crimes against minors or so on and so forth, or pornography. And as you know, recently they've charged him again in federal court for what I believe is essentially the same thing. Now, Diva Divine Light and I had a light debate on whether or not it was double jeopardy, and it's obvious that it's double jeopardy, but it's just an exception, and the exception is called dual sovereignty or dual sovereignty exception to double jeopardy. But essentially, you are charging the man for the same crimes that he was already charged in state court. Now, keep in mind, when someone uses the double jeopardy defense, they are basically saying that not only are you trying to charge me with crimes in the first trial, but you also charging me with crimes that you could have charged me with in the first trial, right? So again, Diva Divine Light and I had this light conversation or a light debate, and for those of you that don't know, is that she basically is an R. Kelly accuser, or she's I don't know how to say this, but she does not support R. Kelly, and her crew wants to see R. Kelly go to jail. And of course, I support R. Kelly. And there's nothing wrong with two people disagreeing, so long as they do it on an intelligent level, and they're respectful. We don't have to be mortal enemies because we disagree on on this subject, and we don't have to disrespect each other because we disagree. And I actually encourage people who disagree to come to my channel and provide commentary, because I think it makes us all better when we have friendly debates among each other. We don't necessarily have to leave that debate flipping sides, but I think it just makes us better, better people, and it enhances our understanding of the law, and it can challenge us in some ways. So in this particular case, she's actually challenged me to finish up a video series, which I had already started, about this whole thing. So basically, I started a video series a long time ago, and that video series was called R. Kelly May Beat the Conspiracy to Defraud the United States charge, right? And for the most part, in that video series, I have the first video, R. Kelly May Beat the Conspiracy to Defraud the United States charge. And then in the second video, I talk about res judicata, which is a civil legal doctrine, which is similar to double jeopardy. Then in the third video series, I talk about witness subpoenas, body attachments, and obstructing justice. And what I had planned to originally do is that I was then going to create a fourth video called Double Jeopardy, and that video was just going to be a basic primer. And then I was going to follow it up with probably a fifth video explaining why the case against R. Kelly in Illinois is essentially double jeopardy. The federal case in Illinois is essentially double jeopardy, and why it should not be allowed to be permitted, right? Or why they shouldn't allow that case to go forward. So what I'm going to do now is that I'm just going to try to wrap all that stuff up in this one video. Again, Diva Divine Light motivated me to come back and find this unfinished video series, and just go ahead and top it off. I think I need to rename all these videos in this series in and of itself. You guys let me know what you think, if this video series is named appropriately. But at any rate, I wanted to come back and just kind of tie all this stuff together. Now, I do want to say that the third video is very important: witness subpoenas and bodies attachments and obstructing justice. This video is important because in this video, I go over why a lot of things that they're trying to do in a federal case could have been done in the first case. They chose not to do it, right? So that third video is very important to basically view and go over. I'll try to leave a link above for the third video, and I'll also try to leave a link above for the video series in general. But it's the third video is very important because all of this could have been done in the state case, but they chose not to do so, right? So now, getting back to Diva Divine Light, and what we're talking about is the sovereign, what is it called? I'm losing my train of thought here. It's late. Is dual sovereignty doctrine, which basically means that the state and the federal government can essentially charge a person with almost essentially the same crime because they're two different sovereigns. In addition to that, two states can actually charge a person with the same crime because they're two different sovereigns, if it makes sense for them to do so, right? So, with that said, with that said, I'm going to first let you know, right, that several states oppose this type of prosecution. I think there's about 20 states that oppose it. I think California is one. And they have, and when I say they oppose it, they have statutes, or I'm sorry, they have statutes that prohibit it, right? So North Dakota, Minnesota, they both have statutes that prohibit this type of thing. And I think California also is a state. There's about 20 of them. I don't have a list of those 20 states. I actually tried to find it, but I just gave up. But if need be, if someone's really truly interested, send me some money and I'll put together a list. But just know that there's 20 states out there that basically oppose successive prosecution of essentially the same crime. Now, again, when we're talking about successive prosecution, or we're talking about double jeopardy, we not only mean the charges that were actually filed against a person in one case, but we're also talking about charges that could have been filed in the first case, right? So again, charges that could have been filed in the first case, and again, that's why the third video is important: witnesses, subpoenas, body attachments, and obstructing justice. That video is going to be important because I'm going to point out to you why all of that stuff could have been handled in the first trial, right? But getting on to this video, one of the things that basically could be used as an argument for the defense, Rkelly's team, to basically have the Illinois case, the Illinois federal case, thrown out. Now, remember, there's an Illinois state case, which is based on totally different charges. We're not talking about that third case or the Illinois state case. We're talking about the first Illinois case in 2008, the first Illinois state case in 2008, and the federal case against Rkelly, the conspiracy to defraud the United States. We're not talking about the third state case, which is basically a totally different set of charges, right? But anyway, the defense can argue that the federal case should be thrown out. And one of the things that they could do is that they could just say, hey, well, several states prohibit this because this is essentially successive prosecution. They don't even have to use the argument or the name double jeopardy. They can just say, for example, these states basically don't allow this. This Illinois shouldn't allow this as well, so on and so forth. The other thing that they can do is that they can do a Blockburger test, right? So I'm just going to read verbatim what's here. Blockburger test is a test in a criminal law which states that a person cannot be tried for lesser and greater crimes using the same evidence in subsequent trials. However, a person can be tried on lesser and greater crimes using the same evidence if the crimes are tried together in one trial. Okay? This does not constitute double jeopardy because the defendant is not being tried twice using the same evidence. Okay, so this test is derived from the Supreme Court case Blockburger v. United States. In this case, the Supreme Court set an important standard to prevent double jeopardy. The following is an example of a case of case law on the Blockburger test. Under the Blockburger test, a defendant may be convicted of two offenses arising out of the same criminal incident if each crime contains an element not found in the other. The appellate court determines whether each crime contains an element not found in the other by examining only the relevant statute, the information, and the bill of particulars, and not the evidence presented at trial. So, in this situation, in the Rkelly case, you'll see that the conspiracy to defraud the United States, in that case, they're going to have to use some of the same claims in the 2008 case to establish the claims in the current case of the conspiracy to defraud the United States. And because they have to do that, I understand that they're adding on the conspiracy to defraud the United States, but in order to even be able to argue that, you have to add in the elements of the 2008 trial. And if you have to do that, then the court should basically dismiss that case based on the Blockburger test. Agree, disagree, questions and comments below. Let me know what you think. Now, there's actually something else that actually should bar a trial in Illinois, in the federal district of Illinois, for the obstruction to defraud the United States. And basically, if you go to the Departments of Justice website and you look on the authority of the United States in criminal divisions matters prior approvals, and you basically go down to, where's this thing at? It's hiding from me. Let me see if I can find it. Jesus. Oh, dual and successive prosecution policy, petite policy. So you click on that and you'll see that, let me enlarge this a little bit. And you'll see that this is the policy that the federal government should be using when it determines whether or not it's basically going to prosecute somebody. So, statement of policy. This policy establishes guidelines for the exercise of discretion by appropriate officers of the Department of Justice in determining whether or not to bring a federal prosecution based on substantially the same facts or transactions involved in a prior state or federal proceeding. Now, again, in order for the government to argue conspiracy to defraud the United States, they're going to have to argue some of the same elements in the 2008 trial, right? And this is the guideline that should have been used, right? And it mentions case Rinaldi v. United States. And then it goes on to say, although there's no general statutory bar to a federal prosecution where the defendant's conduct already has formed the basis for a state prosecution, Congress expressly has provided that as to certain offenses, a state judgment of conviction or acquittal on the merit shall be a bar to any subsequent federal prosecution for the same act or acts, right? So let me read that again because I kind of mucked that up. Although there is no general statutory bar to a federal prosecution where the defendant's conduct already has formed the basis of a state prosecution, Congress expressly has provided that as to certain offenses, a state judgment or of conviction or acquittal on the merits shall be barred by to any subsequent federal prosecution for the same acts, right? Then it goes on, and it basically gives a statute, actually, a couple of statutes, right? Actually, let me see if I can find one of these. We're not going to look at all of them. That's not really relevant, so we're just going to move on. Then it goes on. The purpose of this policy is to vindicate substantial federal interest through the appropriate federal prosecutions to protect persons charged with criminal conduct from the burdens of associated with multiple prosecutions and punishments for substantially the same acts or transactions, to promote efficient utilization of the department resources, and to promote coordination and cooperation between federal and state prosecutors. Okay, so again, they basically break it down for you. The purpose of this policy is to vindicate substantial federal interests through the appropriate federal prosecutions to protect persons charged with criminal conduct from the burdens of associated with multiple prosecutions and punishment for substantially the same acts or transactions, to promote efficient utilization of the department's resources, and to promote coordination and cooperation between the federal and state prosecutors. So again, if you go back and you watch the third video, which I'll probably try to put a link again above, you'll see that everything that they're bringing now in this obstruction to defraud the United States could have been brought in the 2008 trial. They knew about all of this stuff in the 2008 trial, and I point out how they knew in that video, but yet they're only bringing this up now. And I argue the purpose of them bringing this up now is because they just want to nail him. They want to nail Rkelly so bad that they're even breaking their own policies. They're breaking their own policies, and they're basically ignoring several laws that would prevent this type of prosecution for Rkelly, right? And then it goes on. This policy precludes the initiation or continuation of a federal prosecution following a prior state or federal prosecution based on substantially the same acts or transactions unless three substantive prerequisites are satisfied. First, the matters must involve a substantial federal interest. So let me stop there. I believe that there's no federal interest in this case. And if there is a federal interest, that federal interest is already served in the New York trial. So actually, we have a situation where there's double jeopardy on top of double jeopardy. Because, for one, you shouldn't even be bringing these charges against Rkelly in the federal district of Illinois, right? And then if you really want to bring these charges, why not just have one case, right? And just put all those charges in that one case. They have the New York trial, right? And if they're going to argue the RICO, then they could also include the Illinois case in that RICO. But they don't want to do that because they want to basically create this gauntlet that Rkelly has to run, where he has to waste his time, money, and resources running from one court to another. And they want to create a situation where if they don't beat him in New York, they want to drag him back to Illinois to basically try to get him in the federal court in Illinois. And if they can't get him in the federal court in Illinois, then we're going to get him in the state court on totally different charges. If we don't get them in the state court of Illinois, then we're going to drag them over to Minnesota, actually, or I forget that one state where there's this one case against him that nobody ever really talks about right now. If you remember the name of that state in that case, comments below. But you get what I'm saying. Everybody can see that this is essentially nonsense, and you're basically committing double jeopardy in the federal jurisdiction now, because you could essentially bring these charges in either New York or Chicago, but it doesn't make sense for you to bring these charges. It doesn't make sense for you to split these charges up, because that's what they're doing, right? Because in my opinion, the the conspiracy to defraud the United States and the RICO charge are essentially, they're not the same exact charges, but they belong together, right? Those charges belong together. So it's federal court. You could bring the same case that they have in Illinois in New York, because New York is all about the RICO. So you can basically encompass all those states. Uh, Case in point, they're talking about the Aaliyah marriage license in New York, when the Aaliyah marriage license scandal allegedly happened in Illinois. So if you're going to do that in New York, then you could have done all these other charges in the Illinois federal court. You could have put those in New York, but they don't want to, again, because they're trying to basically create this, this situation where he has to waste all his time and resources going back and forth to court, and basically he's going to lose based off of just running out of resources and just exhaustion. They're basically just wearing him down, right? So there's no real federal interest here, and all the charges, and when you watch the third video, you'll see why there's no federal interest, because all those charges could have been brought in the state case in 2008. And again, I also point out, as I've already argued, that the federal case in New York could have contained these same charges. Then it goes on. Second, the prior prosecution must have left. Second, the prior prosecution must have left that interest demonstrably unvindicated. From my opinion, they had the case, and that case was ruled on. They had a trial by jury, and the jury basically made their verdict. If they wanted to, they could have brought all these other charges into the state case. And again, if you watch the third video in that series, I explain why they chose not to do it. And third, applying the same test that is applicable to all federal prosecutions, the government must believe that the defendant's conduct constitutes a federal offense, and that the admissible evidence probably will be sufficient to obtain and sustain a conviction by an unbiased trier of fact. So I don't believe that Rkelly did anything that would basically be an offense to the federal government, and it's basically going to come down to the witness, the alleged witness victim's words against Rkelly's. Right now, with that said, you have to understand that from my perspective, these alleged victim witnesses were more than likely given plea deals, because I believe probably what's happened is they went to one of the victims, and they basically, well, not one of the victims, but I believe they went to the victim's parents, and they basically probably threatened the victim's parents with jail time if they didn't testify against Rkelly. And God forbid, they probably even threatened the actual victim with a conspiracy to defraud the United States, because they probably would allege that the victim went out of the alleged victim went out of the state. And I talk about all this in the third video. They're going to allege that the victim and their parents went out of the state to avoid being a witness, so on and so forth. But I don't think that flies, because as I explained in the video, that they could have gotten the alleged victim, to come back and testify, and they could have charged the alleged victim parents with obstruction of justice. Then Again, I explained all that in the third video. So I don't believe there is any real federal offense here. And again, I think it's all going to come down to the alleged victims' word and the parents of the alleged victims' word against Rkelly. And for the most part, this is all just nonsense. Now, I've already shown you that the policy of the federal government is not to have successive prosecutions, meaning that the state has already charged them. The federal government's policy is not to come behind the state and try to charge them again. They're violating this policy. If you disagree, cool. Let me know why you disagree. Comments below. Please be respectful. And again, I'm not on top of my game. This is at 2:20 a.m. in the morning, and typically my delivery would be better. But essentially, it is what it is. The federal government policy, and you can see it right here. I'm on the Department of Justice website. Their policy is not to have successive prosecutions, and they're breaking that policy. Then on top of that, you also have the Blockburger test, which basically says if the second charge is going to have elements of the first charge, then you shouldn't be bringing that case. And it's clear that in order to argue a conspiracy against the United States, you're going to have to argue elements of the first case, and you're going to have to argue things that you could have brought in the first case. And again, in the third video in my series, witness subpoenas and bodies attachment and obstructing justice, I explained why that, number one, they could have gotten the alleged victim witness to come back to Chicago and testify. I explained why they could have charged people with obstructing justice then. And I talk about, the subpoenas and, how they could have used the subpoenas to get these people to come back for court. And for long story short, they could have just stopped the case until they got these people back into court. They chose not to. That's not Rkelly's fault, and it's more on the fault of the government. So, that's all it is to it. That's pretty much it for this video. I know I kind of like rushed through the concepts, but you can basically see where I'm going with all this. Let me know what you think. Do you think I'm full of it? Do you think I just misunderstood some of these legal doctrines and these legal principles? Do you think that this case, the federal case in Illinois, should go forth against Rkelly, which is the conspiracy to defraud the United States? Should that go forward? Let me know what you think. Questions or comments below. Please like, share, and subscribe.